Welcome to The Laughing Litigator.
Hey everyone, welcome back to an all-new episode of The Laughing Litigator with attorney Ray Hsu. Ray has spent more than 14 years untangling California's wage and hour rules, and today he's talking about the mistake that keeps small businesses up at night, and that's employee misclassification. California says the ABC test makes things simple, but if you've ever tried to follow it, you know it's simple, with air quotes, in the way California laws are simple. One wrong decision and you're facing overtime claims, meal break penalties, pay stub violations, waiting time penalties, and possibly your own personal liability. Today, we're asking Ray to walk us through how misclassification actually works in the state of California, why employers keep getting it wrong, and how fast the numbers add up once the labor code gets involved.
All right, everyone. Thank you for having me. And as I always said, if you need more information, just go onto the website, www.rayhsulaw.com, www.rayhsulaw.com for more specific information for the cases we handle, and also for any information that you want to discuss with us, please feel free to contact us through our website. And today we are going to talk about the employee misclassification in California. It is a legal knowledge that everybody should understand. Again, it's 2025 right now. There's no reason you cannot find a lawyer to discuss employee classification, whether or not you can hire this person as an employee or independent contractor. So again, this legal podcast is more like a community service program. So it is not intended to create any attorney-client relationship, and there is no attorney-client privilege. All right, so let's get it started. So before we talk about employee or independent contractor, so let's start with the definition of full-time employees. And your first reaction is, oh my God, who doesn't know what full-time employee is nowadays? But let's look at what the law says. Under California Labor Code, a person who works 40 hours or more per week is a full-time employee. Why is that important? Because under the Affordable Care Act from the Obama administration, people who work 30 hours or more in a week or 130 hours in a month will be considered as a full-time employees. Why is it important? Because, well, first, you as an employer can classify any workers working less than 40 hours as a full-time employees under your company policy, under your employee handbook policy, but that's not the law. However, as an employer, you will need to provide health insurance under the Affordable Care Act if you have 50 or more employees. And sometimes some company will only hire part-time workers to avoid this situation. In 2024, I overheard a very famous Taiwanese restaurant called Din Tai Fung, Dingtaifung. Well, I overheard it. So they basically hired a lot of part-time workers, and only the managers work full-time. So if you use the same mode of operation, make sure when it comes to your part-time employees, they will not be classified as full-time employees under the Affordable Care Act. Otherwise, you will have to pay for every part-time employees, sometimes every part-time employees, or all of the full-time employees' health insurance benefits. Then talks about the misclassification thing between employee and independent contractor. So in 2018, California Supreme Court has a decision on the test for employee versus independent contractor. In the Dynamax case, basically, California Supreme Court said your contractor must satisfy the ABC test to be an independent contractor. And at that time, when the decision came down, there was even a joke about ABC test name, calling it an anxious business community test. But let's talk about what ABC test is. Under the California Supreme Court decision, you must satisfy all three tests, A, B, and C. Otherwise, the person is an employee or presumed to be employees. under the A test, this person is free from control and direction of the hiring entity. So, AKA no close supervision. This one is actually easy to satisfy because a lot of the job does not require close supervision. And the B test, the second test, the work performed is outside the usual course of the hiring entity's business, AKA not in the same industry. This one usually will fail. This one will work when, for example, you are a CPA, you are a lawyer, you are a doctor, you hire someone to paint the wall inside your office. You are a professional and the person is a renovator or a painter. Then, of course, you can satisfy this test as not in the same industry. But it cannot be something like you are, for example, a merchant, or you are a lawyer, you are a CPA, you hire someone for the front desk, and you try to argue, oh, the person is only a receptionist, it's a caller, it's more like a telemarketer caller, so we are not in the same industry. No, the person works in your industry to help you get business. That means you guys are in the same industry. And then the final test. The person is customarily engaged in the independent established trade. That means the person has to have his or her own independent business. Usually the person has to register his or her own business with their own city business license, or at least advertise that he or she is doing an independent business. Cannot be something like you think the employee is independent. So that's very important. Before 2018, the Borrello factor was the only law that to determine whether the person was independent contractor or employee. And if you ever went to state labor commissioner for a hearing, for the administrative hearing to determine whether the person is independent contractor or employee, these are the 9 factors that actually go through to see if you satisfy at least 4 or 5 out of them, then the employer can establish the worker as independent contractor. These 9 factors are different with the ABC test in many ways. 2018 Dynamax case, you have to satisfy all 3. If you fail any one of them, the person is employee. But before 2018, you don't have to satisfy all 9. You can satisfy sometimes 4 or 5 or even more. The more the merrier, then you get it. So to some extent, the 9-factor Borrello test gives some of the employers a way to show that, look, we are really a small business and this is how we operate, and therefore the person should be considered independent contractors. But unfortunately, the 2018 Dynamax case deprived that opportunity. So if you fail any one of the 3 tests, the person is an employee. And now we come to the common excuses for employer, especially small employer, to say they don't understand, they didn't follow the law correctly. Usually they say something like, well, we are just a small business. The employee only worked for a few days or a few hours, so we just give them 1099. Does not understand the law. The employee agrees to be a 1099. Or the employee signs an agreement and say, I want to be 1099. Or the employee only wants cash and does not have social security number, or the person is from Home Depot, Walmart, and we just grab the person to work for us. Of course, we didn't even think about this person has to be in a payroll or to become an employee. Well, unfortunately, under the 2018 case, if you don't satisfy all 3 tests, the person you hire will be employee. And especially on the last note, the person from Home Depot, Walmart, there's an English phrase called day labor. So these people are employees regardless. They were never called day contractor. So consequence for misclassifying a worker in California under the labor code. So if you hire a person and misclassify the person independent contractor, you most likely just pay the agreed upon daily wages, weekly wages, or monthly wages. And you pay just like once a month or once a week. Sometimes just once a day. But then they will have serious legal consequence here. First, did you pay overtime under labor code? 510. Under the Labor Commissioner proceeding can goes back 3 years. In Superior Court of California, it can goes back to 4 years under the unfair competition law. And because you treat a person as an independent contractor, you are not going to care when he took a meal and rest break. So that's going to be 2 hours premium pay per day based on his regular wages at that time. And then because of all these violations, it's going to be waiting time penalties under Labor Code 203 for 30 days of wages. Pay stop penalties because the person is unlikely to be on the payroll if you treat the person as an independent contractor. There's a $4,000 maximum penalty per person. And because you treat the person as an independent contractor, you most likely will not reimburse any cell phone use, gas mileage for cars, and tools for work. That's also a violation on the Labor Code Section 2802. And there will also be a double penalty. I call it a double penalty. It's actually called liquidated damages under Labor Code Section 1194.2. And also attorney's fees and costs, 1194 Labor Code. So before I go into the calculation of the potential liability for a person or an employer who misclassify a worker as an independent contractor, I want to talk about one more issue, which is the management exemption, before we talk about that math calculation, liability calculation. So just like I previously said, when in doubt, when you are not clear about the law and you don't even want to spend the time to talk to a free lawyer in California, then presume your workers are employees, not independent contractors. And always pay your employees hourly wages. And you can look at some guidelines from California wage orders. And those wage orders are published by the Division of Labor Standards Enforcement, which is our California Labor Commission. They have very useful information. And they are also industry specific. You can look at number 4, number 5, or number 6. And sometimes it will even educate you in certain special situation, you can make this person exempt from overtime. Like, for example, the person can be commission exempt, the person can be management exempt. But I want to cover management exemption today. First, it's very important to understand under the management exemption, if you establish the person as a managerial employee, then you don't need to pay overtime, you don't need to care about meal and rest breaks. But you have to satisfy 5 elements. For example, the monthly salary of the managers have to be at least 2 times the minimum wage, which means the monthly wage or the annual wages after you calculate it into the equivalent hourly wages have to be at least 2 times the minimum wage in that year. For example, in 2023, the minimum wage for employer with less than 25 employees was 15.5, and 2024 was $16 per hour. Then in 2023, your manager needs to at least earn $5,373.33. And in 2024, for $16 per hour minimum wage, your management employee needs to earn at least $5,546.66. If the salary does not even meet this requirement, we don't even need to talk about the rest of the 4 requirements. And then the second requirement is the manager has to be able to supervise 2 or more employees. Sometimes in small business owner employer context, you have a manager, but you have only 1 people. Sometimes you have a manager, but he doesn't supervise anybody. Like, it's a department head, or for an extended time because the reorganization, the layoff, the termination, the entire department actually has nobody for the manager to supervise. Then you will have a problem with the second element. And then the third element, the ability to recommend hiring or firing employees. He either has the ability to do that, or he could actually hire or fire employees. And for independent discretion, sometimes he can make decisions without asking permission for every single little things from you, the owner. And also the final requirement, 50% more of the time, the person was tasked with management duties. So you cannot have a receptionist doing only non-managerial work and say, oh, the person is a manager because I call her a manager, I gave her a lot of money. If it turns out she doesn't work 50% more of the time doing management level work, then the person could still be treated as a non-exempt employees, and you will have to pay overtime for all the hours you work, over 8 hours a day and over 40 hours a week. So let's look at the example that I've seen in the past 14 years. So I'm going to give you an example of domestic worker, nanny A, chef B, and on-site property manager C, and the common problem and the tragic we see in wage and hour litigation on behalf of the employer. So consequence in violation, actually it is codified under Labor Code section 515, D as dog, D2, subsection D2. A fixed amount of salary only pays for 40 hours per week, notwithstanding any private agreement to the contrary. So if the person was non-exempt, either you misclassify him as an independent contractor or misclassifying as an exempt worker as a management, under the management level, but the person actually was non-exempt, there could be a lot of problems, especially the person work a lot of overtime hours. And we have an example here. Take a look. Say you hire a worker, nanny A, chef B, or manager C from 2020 to 2024. At that time, you promise to give them work 6 days a week, 9 hours a day, and they agreed. And then you say, okay, then you work 11 a.m. to 8 p.m. every day with 1 hour, with only 1 hour break. And then I say, okay, fine with it. I'm fine with it. And then you, as a generous employer, actually use $16 an hour, which is more than the minimum wage in 2020, and say, okay. So based on my calculation, the person, if they work 6 days a week, 9 hours a day, and the calculation based on $16 per hour will be $976 and per week. And then each month is about 4 weeks. So how about I just pay you $4,500 per month? And the person in 2020 will be, oh yeah, sure, it's not bad. Especially they will receive some benefits on the go. And then the situation happens. After 2-3 years, the person decided to sue you for wage and hour violation. And let's see what happens. Huge mistakes. Based on $4,500 a month, and the person worked for 3 or 4 years. But 3 years later, the employees sues for overtime and other labor code violation. Under Labor Code section 515 D2, remember this monthly salary only covers 40 hours per week, notwithstanding any private agreement to the contrary. So all the hours over the 8 hours a day and over 40 hours per week became unpaid. So let's calculate. So the hourly wage for $4,500 per month will be $25.96. And the overtime wage rate for $25.96 will be $38.94. So, and based on the previous example, 6 days a week, 9 hours a day will be 14 hours overtime per week times $38.94 times 52 weeks a year and times, let's just say 3 years. Then you will be facing $85,044.96 without adding other stuff just to begin with. So when I say when it rains, it landslides. So when the person sue you under this scenario, will not just sue you for overtime, whether it's at the labor commissioner level or at the superior court level, with or without a lawyer. Overtime, $85,000. Meal and rest break, 2 hours premium pay, times $25.96 regular wages, times 6 days a week, times 52 weeks a year, and times 3 years. $48,597.12. And then waiting time penalty, 30-day penalty, $6,230.40. Pay stub violation, $4,000 maximum penalty. Liquidated damages, other penalties, attorney's fees and costs, give you $30,000. This employer is looking at a problem of at least $173,872.48. This problem is not even new. The law is also not even new. So if you are still making the mistake like the employer given in this example, then it means you are living under the rock or you're still living in cave. Please do not make the mistake like these employers made in the 1990s, in the 2000, 2010. We live in 2025, 2026 era. So then if you are the employer and you face this problem, sometimes the client will ask, how about just abandon ship? Can I just quit my company and be done with it? Well, unfortunately, after January 2016, it became almost impossible because Governor Jerry Brown actually signed into new law under Labor Code Section 558.1, basically saying any officer, director, or management agent who cause to violate any the certain selected provision of the labor code will be liable for the wage claims individually, even though the company was registered as a C Corp, S Corp, or LLC. And under the Federal Law Fair Labor Standards Act, there was always individual liability since 1938. So sometimes we have clients who try to outsmart the legal system by transferring the company to other friends or other relatives or other family members to try to avoid liability. But please understand, California lawmakers actually receive a lot of information and complaints about certain employers who open a company, get sued for wage and hour violation, and then just close the company and just open another one. They already find out how to deal with it under Labor Code Section 200.3, successor employer liability. If your company and the next company basically share the same facility with the same workers and managers or even the owner or family members, the new company will still share liability with the previous corporate entity. And then lastly, I want to talk about the pay stub violation under Labor Code Section 226. Does your employee pay stub have the 9 items that was required? In previous episode, we talk about that certain CPA forgot to put the employer address in the pay stub violation, causing a $160,000 problems because the employer had 40 employees times $4,000, $160,000. So that's something you can Google Labor Code Section 226 and make sure your pay stub have all 9 items or it's compliant. For $4,000 per employee, if you have 10 employees, $40,000, 20 employees, $80,000. And if you're ever being investigated by Labor Commissioner for different citation for pay stub violation, under Labor Code Section 226.3, there's a different penalty which can easily add the penalty based on only 5 employees for 3 months violation to $26,250. In 2024, finally, California Supreme Court in the Naranjo versus Spectrum Security Services Inc. case basically re-establish or kind of affirm the good faith defense for pay stub violation and also waiting time penalty. But again, this shows that labor employment law is ever changing. And if you ever have a question, you need to consult a lawyer, consult your AI, and basically understand what's really going on. Please stop living under the rock or in the cave, because California labor code is very important for every employer, especially small business owners, to understand before you start to hire a lot of people. And that will be all for today's episode. Thank you.
That's today's tour of the world of misclassification, or as California calls it, the gift that keeps on billing. Thank you for listening to The Laughing Litigator with Ray Hsu. To connect with Ray, do me a favor, visit rayshulaw.com today. Don't forget to like, subscribe, leave a review, and comment, or share the episode with someone who needs to hear it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.